Good evening, everyone, and welcome to Estate Planning Workshop. This is part of Bexley Public Library's Life Transition Series. I want to welcome you this evening. Mitch Adel, he's an attorney and a managing partner of Cooper, Adel, Vu, and Associates. He will be our speaker tonight. Mitch educates adults of all ages, including seniors and their families, about estate planning and elder law issues. He is going to cover topics that you can use to develop your own estate plans, and he will be answering your questions. So at this point, I'm going to turn it over to Mitch, and I'm sure that he will be answering all of your questions about estate planning. Thank you.
Thank you. All right, good evening, everybody. Good evening. Oh, God, that was a great opening. Everybody's wide awake now. That's excellent. All right, so as you can see behind me, my name is Mitch Adel. I'm a certified elder law specialist. I'm going to help you understand a lot about what that designation means in a second, but I'm also the managing partner, as Sue pointed out, of a firm, Cooper, Adel, Vu, and Associates. Let me give you a little bit of a history, because you might have seen us before. My partner, Tom Cooper, actually started the firm back in 1982 in Centerburg, Ohio. And one of the things, and one of the happiest moments of where I am right now is it's been a long time since we've been able to say that we can service the Columbus market. Years ago, Tom used to do a ton of seminars here in the Bexley area, and now we have an office in Hilliard. And for those of you, I should point this out, for those of you after we talk this evening, if you want to take the opportunity to come in the office, spend some time with me and go over some of the things we talked about, I think there's probably where you would go. But depending on, again, where you live in the city, you might even jump up to Centerburg, just north of Sunbury. All right, let me tell you about that designation. First, here in the state of Ohio, I think we have some 37,000 attorneys. That's 37,000 people that went to law school, passed the state bar. Bar is offered in February and July. July results came out actually last Friday. Now think about it. There are a bunch of attorneys who passed the bar, went to law school, passed the bar. They are now attorneys as of last Friday, not technically until they're sworn in, but they are competent in the eyes of the state to be your attorney. They can practice divorce law. They can do bankruptcies. They can do traffic tickets. They can prepare wills. They can prepare trusts. Now, there's an organization out there called NALA. NALA is the National Academy of Elder Law Attorneys. In order to be a member of NALA, you have to pay an annual fee. You pay roughly a $500 annual fee. You are now part of a listserv. And when someone in the area Googles estate planning or elder law attorney, you pop up. Haven't practiced a minute. Now, all of a sudden, you got this special designation. The reason I point out that certification, in all of your books, you all have this blue pamphlet. Now, as you saw on that last slide, there are less than 37 certified specialists here in the state of Ohio. All right. 3 of them are actually at my office, my partners, Tom, Dan, and myself, but 37 certified elder law specialists. And again, you can read in this pamphlet what it means to become a certified specialist, but as you read it, here are the highlights. You have to practice a longer time. You have to have peer reviews. There's additional testing that goes into it. And what you're going to find tonight is that, it may not be me that you decide eventually that you want to have this plan done through, but seek out that designation. Work with someone who's a certified specialist, especially as you hear some of the examples tonight. All right, now, the number one question I get when I tell people I'm a certified elder law specialist, what is an elder? What's a senior, right? At what age do you have to start working with someone like me? The easiest thing I can tell you about that word, it has nothing to do with age. Yes, it has to do with the things that happen to people as they get older. As people get older, they have a tendency to have more health issues. More health issues might lend to needing in-home care, assisted living, or nursing home. As people get older, they get closer to the end. How do we make sure when they pass away, there's not a big mess for their family when they're gone? But believe me, everybody in this room, including myself, one car accident away from either of these 2 problems. That word has nothing to do with age. It has to do with 2 beliefs that are so important. Not only are they on this slide behind me, but as you can see, they're on the front of all of your books. And they are these. You shouldn't have to lose everything you worked a lifetime to accumulate. Why? You don't know all the rules associated with what happens when someone gets sick? How do we make life easier for those you leave behind? so that when you pass away, your family doesn't have to jump through all those extra hoops, spend all that extra money, all that extra time to get the things you leave them into their name. Anybody here married? A couple of you? How do I get both spouses to the finish line? The other day, a family come in, they had $6,000 a month of retirement income. Husband had a $4,500 a month state pension. He had $1,000 from Social Security, and his wife had $500. Now, when he passes away, his pension goes with him. She'll get his Social Security, but she loses hers. They go from $6,000 a month to $1,000 a month. Now, that grocery bill is going to go down, right? One less mouth to feed, but every other bill stays exactly the same. It costs the same amount of money to heat the house for two people as it does one. So how do we make sure that assets are preserved so both spouses make it to the finish line? Those are the concepts we're talking about today. Let's do a little bit of housekeeping. In all of your books, you have this yellow piece of paper. Pull this one out. This is called your seminar evaluation form. Now, I would love to think at this point, so early in the seminar, you could evaluate how well I'm doing, but I'm not silly enough to think that. Here's what I want you to do with this. Put it over to the side, put it in the back of your book. Don't write anything on it front or back right now, right? The reason is towards the end, we're going to actually have you turn that in. We're going to give you this other book called, I got it right here, 101 Questions About Estate Planning, About Trust. I think you'll find it an excellent addendum to the things we talked about today. So don't write anything on that. We're going to collect that later. All right. The other thing, and the other reason I have that in here, I can tell you, having done over 1,100 live workshops, it is difficult to ask a private question in a public setting. And again, since all of you are here, if you do want to take the opportunity to come and spend the time with me, that's sort of going to be your ticket to do it. All right, here's the page I want you to focus on. Pull this page out for me. By the way, if you're at home, pull out a piece of paper, write this at the top. But this is your planning checklist. Now, this should be blank for everybody. The reason it's blank is, well, one, I don't want to pre-populate it so you know what's coming. But the real reason it's blank is I want this workshop to be personal to each and every one of you. Some of the things that we're going to talk about today are going to be important. Some of them won't. I want you to write down the things that are important. Now, obviously, disregard the ones that are not. Now, if you've probably realized this about me already, you will never be able to write down everything I say as fast as I can say it. I don't want that. I want you to pay attention to the examples, pay attention to the stories. And when I get to the end of each section, I will flash this back up, and all you'll have to do is write down 2 words. Now, if you write down everything I say, and by the way, today I'm going to talk to you, this is what I want to talk about. I'm going to talk to you about 5 big estate planning mistakes. 5 mistakes that I see, and let me say this, and I'll say it again and again, not you're making, your advisors are making by not asking the right questions, by not going through all the potential things that you might be worried about. So 5 things that I see almost every day with almost every client. Now, truly, if you write down everything I say, you're going to see my planning mistakes over here, and I got a whole slew of bonuses for you. So let's get started. All right, my first estate planning mistake, thinking that a will alone is an estate plan. I can't tell you how many times I've been in front of a family and said, do you have any estate plan? Have you done an estate plan? I have a will. Now, what's interesting, does anybody know where your assets go if you don't have a will? Probate and the state. Those are the 2 biggest answers I get. Now, first, the state doesn't want your stuff so much that they created this law. They call it the law of descent and distribution. And what that law says is that if you don't have a will and you're married, everything goes to your spouse. If you're married with kids, some goes to your spouse, some goes to your kids. Now, I wish I could give you a better legal word than some, but here's my problem. I got a lot of blended families today, right? Second marriages where maybe the spouse is not the parent of the children. So in that case, different percentages go different ways. Now, by the way, if you have no will, not married, no kids, it goes to your parents. If your parents are deceased, it goes to your siblings, nieces, nephews, aunts, uncles, cousins. It even allows for stepchildren before anything actually goes to the state. But the number one misconception, even if you have a will, you're headed to probate. Think of your will as your invitation to the probate court. If all you do is rely on the will, you're going to probate. Let me give you an example so you understand. Let's say I've got a father, all right, make it real easy. He's got 2 kids, son, daughter. During dad's life, he gets mad at his son, goes into an attorney, says, I want to make a will, leaving everything to my daughter. Dad dies. The only thing he owns at the time of his death is a checking account down at the bank. Daughter goes in. She got the death certificate. See, dad's deceased. She got the will. See, he left it all to me. How many of us think the bank's going to write a check over to the daughter? No way. Why not? Well, how does the bank know that years later, dad didn't what? Get mad at the daughter? Go back into the attorney, make a new will, leaving it to his son? But when dad died, daughter was what? Faster? She lived closer to the bank. The bank doesn't want to make the mistake of releasing the asset to the wrong person. What are they going to tell her? Get us a letter from the probate court judge saying we can release it to you. Now, I don't know if anybody here has been through probate or knows someone who has. How many of us believe this? Daughter can leave the bank, run up to the courthouse, knock on the judge's door, talk to the judge, run back, get the letter, run back down to the bank, get the money, what? Hour? 2 hours, depending on parking, right? Yeah, months, absolutely. Let me share with you my big problems with probate. 3 of them. Here's the first. It takes a lot of time. That's not an average. That's a minimum. I would say probably the average is 6 to 12 months, so probably 9 months is the average, but that is a statutory minimum amount of time. Now, here's why they do it. They want to give creditors enough time to get their bills in so they can get paid before anything goes down to the beneficiaries. Now, think about this. If you have a will, my guess is that you've thought about who the roles are in the will, right? And you have someone who you named as an executor, right? And it's probably somebody in your family, maybe your spouse, and then maybe one of your children, right? And if you thought about it, if you have multiple kids, you might have picked the one who's what? Best with money, the one who's got the best head on their shoulders. Now, think about it. Don't you think that that person that you took the time to figure out, don't you think that they are capable of figuring out what bills have to be paid, pay the bills short of 6 months? Probably one of my biggest reasons to avoid probate. Why would you want your beneficiaries to wait any longer than they have to? All right, another reason to avoid probate. It is all a matter of public record. You don't have to be an attorney. Anybody can go down to the probate court if you know who died. By the way, how difficult is it to find out somebody died? Where do you look? Delivered to your door, right? Think about today with computers, how easy it is to find out somebody died. Anybody armed with that information, you know what they have access to? Who you left everything to, where those people live, and how much they received. Don't you think that's too much information for the public to have? I mean, think about all the scams you hear about. People scamming on grieving widows or widowers. There was a scam years ago called grandmother letters. Have you heard of that before? Here's what happened. After a woman's husband passed away, she started to get all these letters in the mail from people claiming to be grandchildren. The letter said, hey, Grandma, we heard Grandpa passed away. You know, my wife and I were real sorry about that, but we're also having financial difficulty. Can you send us some money? She was sending cash, wiring money. Now, she might not have known that her grandson's signature looked a little bit different, or now he used that P.O. box, but she was sending money. One of the biggest reasons, in my opinion, again, truly to avoid probate, get your information out of the public eye. Another reason to avoid probate, costs a lot of money. There's executor costs, court costs. Who else charges a lot of money in probate? That's right, no secret, it's in the law. I'll tell you what, usually attorneys charge about 4%. There's a form in most counties that has a line, this is how much the estate is, multiply it by 4, that's the attorney's fees. Now think about it, you got a $200,000 house. In order for the attorney to get the deed from your name into your kids' names, what, $8,000? I'm sure you appreciate avoiding probate is far cheaper than going through it, right? Now, I'm not telling you don't need a will. Everybody needs a will, right? Because you need to dictate where you want things to go. You don't want it to go by the state default, so everybody needs a will. My point is, in addition to the will, everybody should be taking steps to avoid probate, right? So to me, the mistake that's being made here, you go into an attorney's office, you say, I need a will, that's where it ends. And why do they care, right? Because at your death, who goes through probate with? Your kids. They do, right? So sort of a win-win. The mistake that's being made is, yes, you need a will, but let's talk also about how to avoid probate. Now, there are a bunch of different ways to avoid probate. And my guess is, as I go through these with you, these are not going to be new. You've heard these before. My point of going through them is so often I see people use the wrong one at the wrong time. Let me give you some examples. First, survivorship, right? Your joint with rights to survivorship. Now, my guess is if you're married or have been married, you might have heard of setting up an asset like that, right? You might have seen it on a deed. You might see a bank account that just says JTWROS, joint with rights of survivorship. This is a great strategy for spouses. This is a horrible strategy for your children. Let me explain. I met with a woman the other day. Her daughter's name was on her house. I said, that's interesting. What, does your daughter live with you? No. Did your daughter pay for half the house? No. I said, well, you got me then. Why would your daughter's name be on your house? She said, Mitch, it was terrific. The house was survivorship with my husband. When he died, all he had to do was take a death certificate down to the courthouse. They put it in my name, no probate. It should be that easy for my daughter. So she put her daughter's name on the house, joint rights of survivorship. You know what she didn't take into account? What happens if that daughter gets sick, gets sued, files bankruptcy, gets divorced? That house is now tied up into that aggravation. Good idea for spouses, lousy idea for children. So what if you were divorced, widowed, single? Think about a beneficiary arrangement. Give you a couple examples. Anybody here who's got an IRA, 401k, 403b, deferred comp, TSP, an annuity, a life insurance policy? You have heard of a beneficiary designation form, right? You have, more importantly, seen where you can list a primary and then contingent, right? Usually spouse then kids, or kids then grandkids. I can't stress this to you enough. Remember to put a contingent beneficiary. I can't tell you how many times I've seen a probate open because somebody failed to list a contingent. And, you know, think about this. I hear this all the time. People say, but Mitch, I don't have to worry about it because I'm very friendly with my financial advisor. They know we have kids. They'll put our kids down, right? Well, here's the problem. Your financial advisors, in my opinion, don't want to take on that. You might call it liability or responsibility. I'm going to call it liability. Here's the reality. How do they know how you want it to go? Let's say you got 4 kids, and at one point you want everything going equally 4 ways. And then you give a large sum of money to one of them to get married, to go to college, to buy a house. You want to even things up at death. What do? Well, you go back into your attorney, right? Make a codicil to your will, make an amendment to your trust. Now saying instead of things going 4 ways, you want to go 3. But think about it. Your financial advisor, your friend knows you have how many kids? 4. Your life insurance, your IRA, your annuity goes how many ways? 4. What's the problem? Well, everybody sees the trust. Everybody sees the will. They know it should have gone in thirds, yet everybody gets a different amount, right? This is one of those, again, if you flip over your book, life should be easier for those you leave behind. Last thing you want are your kids resenting one another because they feel someone got more than they should have. And the reality is, who knows how it was supposed to go? Because now the only person who knows is now unfortunately deceased, right? So good rule of thumb. Anytime you change your legal strategy, make sure you also change your financial. Make sure they are in concert with one another so that they work the same. All right, another way to avoid probate. Payable on death, transfer on death. Heard those strategies before? My guess is you have. All right, here's the issue with payable on death, transfer on death. The best, and in my opinion, truly, the only utilization of this is if you have one child. I'd almost say unmarried, but one child. That's the best utilization. If you have more than one child, there's better ways to do it. And let me give you some explanation behind that. All right. Now, by the way, these are not 2 separate strategies. Transfer on death is more for vehicle titles, deeds to property, stock certificates, and payable death are like bank accounts, right? Checking, savings, money market, CD. All right. Here's the problem with payable on death. Let's say you have a bank account or an investment account that is payable on death, let's say to your 3 kids. And, you know, when I talk to families, I always ask those worst case scenario questions. For instance, like if something happened to your son, where would you want his share to go, right? And a lot of times, as I have it up here, they say, well, I'd want it to go to his kids, right? So here's the issue. The way that payable on death defaults is if you leave assets to your 3 kids and one of them passes away, it doesn't go down, it goes over. So think about it. You accidentally cut out a family that you didn't mean to cut out. So to me, again, the best use is one child, right? All right, now here's the other one, transfer on death. Let's say you have your house, transfer on death to go to your, let's say 3 kids. All right, easy, at death, someone submits a death certificate down to the courthouse. House now goes in whose name? All 3, right? Who has to sign to sell it? All 3 plus who? But their spouses, right? Because here in Ohio, we have dower. Now, again, when I ask families where they want their stuff to go, they usually say to their kids. And when I push them and say, well, what happens if one of your child predeceases you? They say to their kids. You know what they don't say that much? To the spouse of my child. And now here, spouses are included, right? If they don't sign, they could block a sale. You got to get more people to agree on a sale price. So to me, truly, as I said before, payable on death and transfer on death is best utilized with one unmarried child. All right. Another way to avoid probate, trust. Let me tell you the problem with trust. Two problems. One, there are so many different types of trusts. And here's the problem with that. A lot of times, all the bad stories that people hear from their neighbor or their friend about trust is because something went wrong. And what wound up happening in my book is, here's the first one that what happened. It wasn't properly funded. Let's talk about that. All right, so I'm going to try to stand over here to make it easier for everybody to see. All right, so over here, I've got your retirement accounts, IRAs, Roth, right, 401ks. And then over here, I've got, I'll put a line. I think I can do that. Yep. Your house. What I mean by house is real estate, rental homes, second properties, lake properties, cars, airplanes, boats, you name it, right? Personal property, jewelry, guns, collectibles, stamps, bank accounts, pretty easy to understand. Non-retirement investments. Those are not IRAs like brokerage accounts, stocks, mutual funds, right? Savings bonds, right? Those e-ticket bonds. Those are the assets that go in the name of the trust. Go in the name of trust is a very important concept. You could buy the most expensive car in the world. It will not move unless you put what in it? Gas, fuel, right? You could buy the most expensive trust in the world. It will not work. It will not avoid probate unless it is properly funded. Funding the trust means taking ownership of the assets and putting it into the name of the trust. It's not good enough just to write in your trust, my house goes to my son. The house has to physically be deeded to the trust for it to work. And here's where this big problem occurs. All right. So I see a lot of families that they got to trust through, I'm going to say their financial advisor. Here's what happened. The financial advisor maybe went out to their house, talked to them about what they had, and then said, you know what, you should have a trust. I have an attorney who's a friend or a colleague, and he'll do a trust for a very low amount or even free. And what winds up happening is the financial advisor takes all the information up to the attorney, and the attorney drafts everything, and then they send it back with the financial advisor. Now, the advisor's coming back to the house to sell you whatever they're selling. It's fine. And then what happens is they have this trust book that's got all these little sign here, notarize here, witness here tabs. And I'm going to tell you, after you read through this trust, sign your name 15 times, the last thing you want to do is homework. So what you actually do is you take that trust and you stick it on your bookshelf or in your safety deposit box, and that is your trust. You are done. Here's the problem. In the back of the book, they have a letter, and the letter tells you how to fund assets into your trust. Now, what happens is because you didn't look at that letter, the trust remains unfunded for your whole life. Now, when you pass away, your kids go down to the bank. They assume that everything's in the trust. They assume it's going to avoid probate, and the bank says, no, it's in their names. It's got to go through probate. Now, here's good news. The attorney put a will in there, and the will is called a pour-over will. And the purpose is to pour an asset that isn't in the trust into the trust at death for distribution. But don't get me wrong, it's still a will. Where do wills get administered? Probate, right? So it's still going through probate. Now, here's what happens. The kids get mad, and rightfully so, right? Mom and dad paid for this trust. Why are we going through probate? And what happens is the attorney flips to the back of the book. They find that, I'll call it CYA letter, right? And they flip it up and they say, I told them how to get things in the trust. It's not my fault they didn't do it, right? So remember, if you have a trust, make sure it's funded. By the way, I call those attorneys the double dippers. The ones that have no problem making sure that you create a trust, but don't give you really blatant instructions how to get things into the trust. And I'll brag for a second. At our office, we have a department dedicated to helping people fund their assets in their trust. So make sure if you have a trust, just like if you have a car, you properly fund it. All right, here's the other problem. A lot of times the wrong type of trust is created, or more importantly, people don't understand who runs a trust. So if you take all your assets today and you put them in the trust, who would you want to manage them today? You. You're the trustee. You manage the assets. It's your stuff, right? Now, if when you pass away, you've got somebody already lined up to be your successor. See how I have it up there? I have a family member or a professional. Now, I think it's better if you have a family member who can do this for you, one of your kids, maybe a friend, right? Maybe, here's my point. It's probably not your family, but you probably know a family that if I asked them to name one of their kids, no way, they couldn't do it, right? So they have to use a professional. Problem with using a professional, you're right back to paying extra fees. So if you have someone in your family who can do it, it works a lot better. At death, just like these go by beneficiaries, this goes directly down to these kids. Now, what are the benefits? It takes less time. You know, the worst part about probate is, again, all these things up here. All right. But here's what you want. Most people want this. They want one person in charge. They want that one person to pay the bills and distribute the assets. They just don't want to wait 6 months, right? Payable on death, by the way, that's not what happens. Payable on death, all the kids get an equal share and all the kids are involved. This way, you have that one person in charge, just like probate, before any bills get paid and then things get distributed. Trusts are private. They don't get followed up at the courthouse. Hopefully, you're not going to see any of those nosy neighbors, scams on grieving widows or widowers, right? The costs are lower. Remember my example before? $200,000 house. That's all that's in the trust. At death, trustee child, they go to sell it. What happens? The sale is done by the realtor and the title company, right? They do the deed. They deposit the money in the trust checking account. Child distributes the money after that. No attorney whatsoever, right? So much lower costs. And one of the biggest reasons why I think families, especially married families, should look at trust is right here. Think about this. I don't care if a family has been married 50 years or 50 minutes, right? If they have 4 joint children or 2 of his and 2 of hers, they came in together. They agreed on the plan together. Is it fair if you list everything survivorship, right? To make sure it avoids probate. Wife passes away, survivorship to husband. Who can husband leave it to? Anybody he wants. New kids, new girlfriend, new spouse, right? Goes the other way too. The reason that I like trust, especially for married families, you can lock in the beneficiaries. You can make sure that at death, surviving spouse has access to the money, but they can't direct where it goes. It can't go to additional people that you meet later on in life. Now, here's what I'm telling you. Remember, the goal of today, I should tell you this, my goal is not to sell everybody here a trust. I don't believe that. I don't think everybody needs a trust. What I think everybody needs is to avoid probate. If making sure that you avoid probate at your death, if that is important to your planning checklist, please take out your sheet and write that down on one of those lines. Okay, my second estate planning mistake for you, failing to create strong legal documents. I call this your legal document toolbox. In your legal document toolbox, I want you to have 3 documents. Let me explain why they're so important. Let me start with this first one. All right, here's my example from before. I got this trust, right? We talked about what happens when you die, but what happens if you have a stroke and you're incapacitated? Hey, good news. In your trust, I got somebody who can act. But you know, I see a lot of families today who've got a lot of money in their retirement accounts. Here's the problem. There's no joint owner on a retirement account. So if you become incapacitated, who deals with the retirement account? Well, if you don't have anything in place, you have to go through what's called a court-ordered guardianship. Now, if you ever heard of a guardianship before, my guess is it's with little kids, right? When young families have kids, they create wills to name someone to be the guardian. Now, they want to make sure that that person's in charge. Now, make no mistake, since it's done by your will, it's done at the probate court, who is actually the person who's in charge of the guardian. Works the same way with adults. Husband has a stroke. Wife tries to become the guardian. She petitions with the court. She finally becomes his guardian. She has to get a permission slip before she uses his money on him. She has to do an annual accounting of their assets to the court before using money on themselves. Nobody should go through a guardianship. The way around it is by creating a financial power of attorney. Now, remember, I didn't talk to you just about documents. I want you to have strong documents. I don't want you to have just a power of attorney. I want you to have what I'm going to call a high octane power of attorney. Let me break that down for you. First, what's a power of attorney? It is honestly a document that allows someone to stand in your shoes and write checks for you. They can pay your bills, they can pay their bills. So pay close attention to who you name as your financial power of attorney. Let's talk about high octane. I'm going to give you a story. I met with a woman who was married to her husband for 48 years. For the last 8 years following his stroke, she's been using their life savings to pay for adult daycare and home health care providers. She made a promise to her husband he would never step foot in a nursing home. And I'll tell you what, for 8 years, she honored that promise. You know what happened at the end of 8 years? She ran out of money. She had to place him in a nursing home. She had no other choice. She had no other money. Now, here's the issue. They're married 48 years. They got one daughter. The only thing they had left was a $100,000 house. They wanted to go to their daughter. Now, here's what they'd heard, that once someone gets on public benefits, whether it be at home or in a facility, the state today has the right to put a lien against the property and recover it back after death. Have you heard that before? Yeah, it's called a state recovery. They do it everywhere. We'll talk a lot about it later, but they wanted to protect the house from a state recovery. She said, can we still do that? I said, well, you told me your husband can't sign. I don't see how it's possible. She said, don't worry about it. Years ago, we met with an attorney. I have a power of attorney. I can sign for my husband. All right, let me tell you the problem. All right. In 2012, the state of Ohio dramatically changed their financial power of attorney law. They actually made available on the internet an Ohio State statutory power of attorney form. Here's the problem with that form. It is drafted very conservatively. Why? Well, here's what they didn't want. They didn't want anybody able to find it on the internet, print it out, and clean you out, right? So they set it up so the only thing that online form will do is like a glorified guardianship. All they can really do is write checks. You know what they can't do? A wife of 48 years of marriage can't take a $50,000 interest in a $100,000 house, take it out of his name, put it into her name, so that after he gets on benefits and later dies, and then she dies, it passes free and clear to the daughter. You know what? The only reason they can't protect the house is because that 4-page power of attorney wasn't strong enough. Guys, if your financial power of attorney was not created or reviewed by a certified specialist, take out your sheet right now and write, review my POA. The last thing you want to do is get right up close to the finish line and not have the tools to get you across. Make sure that your power of attorney documents are strong enough. All right, let me tell you what happened. All right, 8 years ago when he first had his stroke, before things got really bad memory-wise for him, he still had his capacity about him. They met with an attorney. It was the attorney years ago who drafted their will, helped them with a rental property years ago, helped with their daughter's divorce, did a little bit of everything. And when they needed a power of attorney, he went to the state law. Why wouldn't he? He didn't realize it had to be made stronger. So please, if you already have a power of attorney, take out your sheet and write, review my POA. All right, second document everybody should have is a healthcare power of attorney. Seems pretty obvious, right? One deals with finances, one deals with healthcare, right? All right, here's what's wrong, or not wrong, but here's how you make a financial power of attorney stronger. All right, let me give you an example. So every time you go into the doctor's office, every time you go to the hospital, whatever it's for, when you sign in at the desk, they have you waive your right to that privacy law. What's that called? HIPAA, you know about that. All right, every time. HIPAA is a privacy release about release of information to not only insurance companies, but your family. All right, how about this? You break your hip, you break your arm, go into the hospital, you waive your right to HIPAA there at the desk, they take you in the examination room. Before they put you under anesthesia, they want to make sure there's someone they can talk to. They help you fill that out. Problem is, you take that home, you put it in your safety deposit box or your glove box, that is now your document. Remember, the day at the hospital was HIPAA compliant, the document's not. Make sure your healthcare documents are HIPAA compliant. That's HIPAA. And let me tell you why this is a problem. I have seen documents where people just got them at the hospital. Now, years ago, the hospital bought all these forms, tons of them, copyrighted like 1998, well before HIPAA, and they're still using them up. And as a result, a lot of these documents are not HIPAA compliant. All right, third document everybody should have is a living will. Probably the most recent, most famous case of a living will was that woman years ago down in Florida. Her name was Terry Shiva. Everybody remember that? If you don't, this might help you. So she's permanently unconscious. She's hooked up to these machines. Husband wanted her removed. Parents wanted her to stay on. People drove all around to Florida to protest. Now, I don't want to debate it with you. Let me ask you an easier question. Do you think that her husband or parents will ever talk again? Laughable. They will never talk again for the rest of their lives. What if that was your family? What if two of your kids and your spouse never spoke again for the rest of their lives? Why? Because one of them thought you wanted one thing and another thought you wanted another? It is that easy to tear a family apart. I cannot stress enough how important it is to get these very important decisions in writing, right? Make sure truly that you make sure that they are HIPAA compliant. The other one that I want you to do is this. Make sure they're reviewed by a certified specialist. One more, before I get off my soapbox here, start having these conversations with your family now. Listen, I realize how hard it is to have a life and death conversation around a Thanksgiving dinner, but think about how much harder it is to have in the middle of a crisis. If you have not done so already, please take out your sheet and write strong legal documents. All right, my third estate planning mistake for you is failing to protect an inheritance. Now, we do an advertisement in our office. We do it on Facebook. It talks about the difference between transfer on death, payable on death, and trust. And this is really where you're going to see it, okay? Because if you think about it, transfer on death, payable on death goes directly to the person. There is no, in my opinion, protecting the inheritance. Now, I say my opinion because what are you protecting it from? Well, let me give you some examples. All right, so sometimes when I meet with families and I say, do you want everything to go to your kids? They say, not our kids. Mitch, our kids are doing great. They're doing better than we are. You know what we'd rather do? We'd rather bypass our kids and go to who? Grandkids. But they don't think that an 18-year-old is financially mature enough to get their hands on the money right away, right? So maybe what they want to do is hold it. Allow it to come out when that child needs it to go to college or to buy a house or to get married. Or when they hit a more appropriate age, like 25 or 30 or 35, or like the woman I had the other day who thought her grandchildren would be financially mature enough to use her money at age 65. Probably accurate, who knows? But what a great way to control the distribution until somebody needs it. Now, what if instead of having really successful kids, you had the other ones? Ones that like to spend a lot of money, right? Every dollar they earn, they spend $3. They got the credit card bills piling up. You leave a lump sum of money to a family like this, it's gone in what? Months, weeks, minutes? What if instead of leaving them a lump sum that's gone like that, what if you could stretch it out in payments over the rest of their life? Monthly, annually, pays out however you want it to go, 10 years, 20 years following your death. Make sure that people who are bad with money protect themselves. Sometimes I have beneficiaries where there's a medical issue. Now, depending on the onset of that medical issue, they might be on some sort of government benefit to help pay for care. Now, the issue is if they're on some government benefit and you pass away and leave them money, what happens? They lose the benefit. Good news, they got your money. Bad news, they spend it down. And finally, when they're done spending it, what if that program doesn't exist or they're waitlisted, right? Now, I have a lot of people that say, but Mitch, I got 2 kids, so here's what I'm going to do. I'm going to leave it all to my healthy son. He's going to take care of his disabled sister. And that works out real well unless something happens to the healthy son and the money goes out to some other family and now there's nothing left. If you have a disabled loved one in your life, start looking at special trusts to supplement their benefit, not displace it. All right, this isn't every day, but sometimes I come across the families that don't have any of the 2-legged children, right? They only have the 4. They love them just as much. They want to make sure they're protected just as much. Here's the issue. They don't want to leave all their money and their dog to their nephew to take care of the dog because they know that nephew's going to take care of the dog, all right, right? He's going to take the dog down to the shelter. He's going to take all the money. What if you could set up a sense of checks and balances, a trust to manage the money, and nephew manages the dog at the dog's natural death, money down to the intended beneficiaries. If no kids or family, maybe charities. All right, but kids are the big deal, right? And there's 2 big problems that I hear consistently from families. Here's the first. We live in a very litigious society. People are sue happy. They sue because the coffee's too hot. Minor fender benders turn into big deals. You leave money to your kids, they get sued, they could lose it. How about this one? When I ask families how long they're married, I get 20, 30, 40 years. You know, when I ask about their kids, I hear, Mitch, my son's on his 2nd marriage. My daughter's only been married a couple of years this time. I think everybody here would agree that is a far bigger problem today than it ever was before. I'll tell you, some people see it for financial gain. You pass away, you leave all your assets to your son or daughter, then they get divorced. How much is the spouse going to try and get? Right? So what if instead of leaving assets directly to your kids, what if you could set it up in what I'll call an inheritance castle trust? So that if they have creditor issues, if they have potential lawsuits, if they're going to unfortunately have a divorce, you can, or they're bad with money, you can protect the inheritance that you leave your kids from all the problems that they might have in the future. And let me give you what I'll call cherry on top of this one. Ready? Let's say you have a child who's married and has kids. All right, now think about it. If they have a will, where do you think their will leaves things at their death? Meaning this, you pass away, you leave all your assets to your child, they're married, and they have kids. Where do you think their will has everything go? Think about where your will goes. To your spouse, right? So think about it. If you leave assets to your child, and they naturally have a will that leaves everything to their spouse, and that new spouse gets married, right? Or that spouse gets married to somebody else, they have additional kids, your money's scooting out to some family you never met. How about this? Wouldn't it be nice to leave assets to your kids? They'd be protected from the things I just showed you, and anything that wasn't used up, you were assured went down the bloodline to your grandchildren. Tremendous ways to use trusts. If making sure that the assets or inheritance that you leave to your kids are protected is important to your planning checklist, if you have not done so already, please take out your sheet and write that down on one of those lines. All right, my fourth estate planning mistake for you is failing to include tax planning into your estate plan. I'm going to talk to you about 3 taxes. Let me scoot through this first one. All right. I don't know if you've heard of estate taxes or death taxes, inheritance taxes. See, it's a tax on assets that you leave to someone at your death. If you die and leave things to your spouse, there's no tax. But if you die and leave it to someone other than a spouse, or at second death, you leave it to somebody other than obviously a spouse, your kids, there's taxes over certain thresholds. Now, Ohio had an estate tax years ago. It went away in 2013, gone. Don't have to worry about it. There is still a federal estate tax. Back in 1997, the federal estate tax threshold was $600,000. Anybody know what it is today? 200. It's 12 million. 12 million. Now, it's not going to stay 12 million forever. There's part of a sunset bill that in a couple of years, it's actually going to go down to about 6 million, right? Now, 6 million is still a lot. Here's the issue. Back when the estate tax threshold was $600,000, a lot of times attorneys created trusts for families to deal with the estate tax issue. Now, here's my problem. If you're sitting here today and you already have a trust, take out your sheet and write review my trust. Here's the problem. The language that's sitting in people's older trusts is creating a potential disadvantage for their surviving spouse and their kids going forward. You can do simple amendments within it to fix this problem, but make sure it's fixed, okay? Because a lot of trusts are hardwired to do something else. All right, so here's the big one. Does anybody here have retirement accounts, right? IRAs, 401k? I'm sorry, you shouldn't raise your hands, maybe. All right, I'm sure, I should say this differently. I'm sure a lot of us have retirement accounts, right? All right, now, January 1st, 2020, right before the world sort of imploded with COVID, the first law that passed was called the Secure Act. Now, if you have a retirement account, I hope you've heard of the Secure Act. If you have not heard of the Secure Act, here we go. It changed 2 things with retirement accounts. Both things I would consider to be bad. Now, you might consider them to be a little bit different than that, so let me help sort of explain my way of thinking about it. All right, so if you're sitting here today and you have a retirement account, you probably know this. The money continues to sit in there and grow tax deferred until you hit a certain age when you have to start taking the money out. At what age do you have to start taking the money out? Yeah, a lot of numbers, right? So it used to be 70.5. The Secure Act raised it to 72. That's the required minimum distribution age. And you know what everybody thought? Oh my God, that's so great. I can leave my money in there longer. But you know what? It's not great. If they would have made that 80, would that have been better? No. What it's doing is creating a false sense of hope. Because think about it. Somebody's going to take it out and somebody's going to pay tax. If you're married and you pass away and you leave it all to your spouse, who's in a higher tax bracket? A married couple or surviving spouse? Usually surviving spouse. And now think about it. They have all the IRAs. They have to take out the same RMD that both of them had to. They pay more tax. Here's an easier question. Who's usually in a higher tax bracket? You in retirement or your kids? Yeah. So somebody's going to pay the tax. Your kids in the higher wage earning years are going to wind up taking it out, right? They're going to pay more tax. So sometimes it's not a great idea to leave it in there longer. And then here's the worst part. Not only are your kids going to pay more tax, but they made sure of it. There used to be something out there called a stretch IRA. I don't know if you've heard of that. That was when you left your IRA to your kids, they could stretch it out over their life expectancy. They couldn't wait till 7.5. There was a separate table that talked about how old they were when you died. And what would happen is they would take out a really small amount every year for the rest of their life. Okay. They eliminated the stretch. 4 exceptions. Ready? Your spouse can still stretch it. A disabled individual can stretch it. A beneficiary who's within 10 years of your age. Now, my guess is if you're going to do that, it's because you don't have any kids and maybe you're leaving it to a sibling. Or a minor can stretch it till age 21, and then they're subject to the new rule. Anybody know the new rule? I'll give you a hint. 10 years. So not only are your kids in their higher wage earning years, but now they have to take it out over a 10-year period. much more tax potentially than you'd pay. All right, so here's my my fix to this. If your kids are in a high tax bracket, oh, I have a slide. If your kids are in a high tax bracket, who's in a low tax bracket? Your grandkids. Well, we already talked about it. You don't want to bypass your kids and go to your grandkids. All right, we have a trust. We call it an IRA garden hose trust. Here's how it works. It allows you to leave your IRA to your kids and allows your kids to dictate which of their kids take it out to save on taxes. Let me give you an example. It's a big example, but I want you to see how this can help a family. So I met with James's mom. James and Jody are married. They have an AGI, adjusted gross income, of $350,000. They're going to inherit 260. They got a daughter, Sally, by the way. She's got no income. She's about to start college. They're going to inherit $260,000 from James's mom's IRA. All right, here's the problem. They want to pay $40,000 for her education. They want to use mom's IRA to do it. If they take it out at their income tax bracket, they actually have to take out $64,500. They have to pay federal tax. They have to pay school district tax, state of Ohio tax. They lose almost $25,000 to get 40. Now, if they did it through this trust and he was able to push it to his daughter, sure, she'd still pay some tax, but she'd only lose $7,600 because she didn't have any extra income. Over 4 years, they would save $70,000 in income tax. For those of you who have not started planning for the Secure Act, please take out your sheet and write planning for the Secure Act. You know, I used to say people who had a lot of money in retirement accounts and not a lot of kids should plan. But nowadays, I'm just going to say anybody who hasn't started planning for the Secure Act should write that down on their sheet and start looking at it. All right. The third tax is capital gains tax. Capital gains tax is a tax on an asset that has a basis. What has a basis? Stock, real estate, your home. Your basis is what you paid for it. If you bought your house for $60,000, turned around years later and sold it for $140,000, you would have a gain of $80,000. Now, I'm not here to ask any trick questions. Is everybody aware, if this is your primary residence, you have that one-time capital gains tax exclusion, right? $250,000 for an individual, $500,000 for a married couple, provided that what? You own and occupy it. Now, here's the problem. I have heard so many times from families, Mitch, doesn't it make good nursing home planning sense to take my house and give it to my kids? Here's the problem. If you take an asset that has a basis and you give it to someone while you're alive, they take your basis. They get it for what you paid for it. Now think about it. Years later, you want to downsize. Yard's too big to mow, too many rooms in the house. Go to sell it, tax is due at your kid's income tax rate. So sometimes things that make good nursing home planning sense are bad tax ideas. We'll talk about better ways to do that in a little bit. But here's the deal. If you pass away owning the property and it passes to your kids at your death, they get the benefit of a step up in basis. They have it appraised. They get it for what it's worth. They sell it. They don't pay any tax. Okay, right. So for those of you, by the way, here's an example. We'll talk about ways to fix that if you want to do nursing home planning with your house still in a second. But for those of you who have already had property given to you, let's talk about fixing a prior issue. This is the worst example I've ever seen. Family came in to meet with me in 2019. In 2001, Dad got spooked about nursing homes, gifted a 400-acre farm to his 2 daughters. All right, here's the problem. Dad paid virtually nothing. He paid $100 an acre for that farm. When he gifted it $100 an acre. When I met with him in 2019, it was selling for $10,000 an acre. It's probably more now. Here's the problem. When Dad dies and these daughters sell this property, they're going to pay capital gains tax on $3.9 million. They're going to owe the federal government almost $800,000, another $277,000 to the state. How long would Dad have had to spend in a nursing home before that planning made sense? Now, here's the bad news. We're 20 years later. You know what they don't want to do? Give it back to Dad. Here's what we can do. We can create a trust. We call it a skyhook trust. We create a trust for the daughters, give Dad certain rights back in it, and at Dad's death, we get a basis step up without having to give it back to him. I had a family that had 10 rental properties. They've gone up in value. They didn't want to be in the rental business anymore, but they didn't want to risk the capital gains. Their parents were deceased, but they had a 97-year-old aunt, healthy up here, physically unhealthy. They created the same trust for the aunt. At her death, basis step up, they sell the rentals without paying any tax. For those of you who have not included tax planning into your estate plan, you're making a mistake. Please take out your sheet and write down if any of those things made sense to you. All right. Now, my fifth topic for you is long-term care planning, or more importantly, failing to protect your assets from the high cost of long-term care. This is what I call your long-term care journey. Now, as I look around the room, I see a lot of people that are hopefully in this retirement stage of your life with this hope, right? That not now, but years and years from now, peacefully in your sleep, you jump from here to there without having to deal with any of this aggravation in the middle. Decline in memory, mobility, in-home care, assisted living, nursing home. By the way, for those of you who are on that side of retirement, still working, take out your sheet. If you have not claimed Social Security already, take out your sheet and write Social Security planning. We are pretty far removed at this point, in my opinion, from break-even point. Social Security is going to go away. I'm going to die before I get my full benefit. You need to start looking at it from a tax standpoint. So if you haven't claimed already, take out your sheet. We are lucky enough at our office to have, I'll call them two gurus who, one of my partners and one of our financial/tax people, but two gurus who go through every day how people should be or when they should be claiming Social Security in conjunction with their retirement accounts. All right, so here's the average cost of a nursing home. All right, you can see the state average, you can see the national average. I got to tell you, we're low. I have yet to see a nursing home for less than about $10,000 in the last 2 years, right? So somehow they're keeping it low. Who knows where? I'm not sure if we want to be there, but all right. So here's the cost. These are monthly costs. I want to give you an example that, in my opinion, kind of blows people's mind. Ready? I met with a daughter. Mom's got $400,000 in assets. Half of it's in a retirement account. Half of it's in a savings account at the bank. Okay. All right. Here's the deal. Daughter's POA. She can use both accounts. Now, what do you think the interest rate on the bank account was? Laughable, right? Probably wasn't paying anything. So the money that's generating more income is coming from that retirement account. So she's got to write a $10,000 a month bill. Where's she taking the money? From the bank account or from the retirement account? The bank account. She was taking it from the bank account. Now, that's bad. Here's why. If the daughter uses all the money in the bank account first and then mom dies, daughter inherits the IRA, what happens? She has to take it out at her income tax rate over a 10-year period. Does she get $200,000? No. She has to pay all the tax. If the daughter had used all the money in the IRA first, one, she would have had a dollar-for-dollar tax deduction, medical tax deduction on what she paid the nursing home. That would have come out tax-free, and at mom's death, the daughter would inherit a bank account tax-free. We call it healthcare tax planning. Blows people's minds, right? And you know why you weren't thinking about it the right way? Because if you have a loved one in a nursing home, you know what you're not worried about? You're not worried about what account the money's coming from. You know the bill will get paid. You're worried about how mom, dad, husband, wife is doing in that new environment, with that roommate maybe, with that TV blaring as loud as it is. Let somebody else help you with these tax issues. All right. Now, again, with the cost of care being so high, it is not long before people go through what they call a spend down. All right. Let's talk about a spend down. Now, first, does anybody know how much the state will allow you to keep if somebody gets sick before they start paying the bill? $2,000, right? Here's good news. If you're married, the amount's more. Here's bad news. This slide is misleading. All right. There is a certain amount of money that they let the spouse at home keep. They call it the maximum CSRA. CSRA. CS stands for community spouse. Maximum community spouse resource allowance is $137,400. Husband gets sick. He's in the facility. He's allowed to keep $2,000. The most the spouse at home can keep is $137,400. Here's what they do. They take everything that husband and wife have that's not exempt. They divide it in half. And if that number is more than that number, the spouse has to spend all of the rest of it down to $2,000. And again, they keep $137,000 for the rest of his or her life. And then I got all these families that say, Mitch, but good news, some of the assets are exempt. Here's bad news. They're coming back on exempt assets. Your house is exempt. Here's the rule. It says for the house to be exempt, it has to be the principal place of residence for the individual spouse. Husband and wife. Husband gets sick. Wife stays in the house. House is exempt. Here's the bad part. They are slapping liens against it. Just like we talked about before, that estate recovery program, they're coming back and they are taking back everything they paid. This is Sue Cunningham's house. Over her life, the state paid $190,000 on her care. At death, they slap a lien against it. Now, let me tell you what happens. Let's say the house passed transfer on death to her son. Believe me, the last thing you do at somebody's death is run up to the courthouse to see if there's a lien. You know what you do? You get it ready for sale. You know when you find the lien? When the buyer gets involved, probably about a week before the sale, and they get title insurance, and the title company says, hey, this guy filed a lien against the property. By the way, this guy is Bruce Burkholder. I'm not picking on him. He's one of 200 debt collecting attorneys the state hired to come back on families. He gets 20%. So if you call him a week before the sale and say, hey, you know what? I didn't know about that lien. Can you remove it? He's going to first, I think, laugh. And you might laugh and say, well, he's not going to be able to do anything. Well, here's what's going to happen. At the closing, the state is going to get, if the house sells for $189,000, state gets it all. This guy gets 20%. They are really aggressive. The good news is they negotiate. The bad news is you don't find out about it until too late. You're not going to walk away from the sale. And that's usually how people get dinged. All right. Here's my biggest advertisement for why I want you to write Avoid Estate Recovery. All right. If your kids are successful, there is no doubt in my mind you have had some hand in that. You have sacrificed in some form or another over your life to get them in the position they're in today. They're off the clock, right? Your job is to make it to the finish line. You're going to own a house. Rarely does someone in the last minute of their lives sell their house to come up with more money. So please take out your sheet and write Avoid Estate Recovery. All right. In order to avoid a spend down, there are two ways. There is an easy way and a hard way. Let's talk about the easy way first. Have somebody else pay the bill for you, namely long-term care insurance. All right. What's the problem with long-term care insurance? Expensive, right? Most people don't think about it till you're older. When you're older, it costs more. When you're older, right, you may not qualify for it. All right. So I like it. I do. My problem is most people I meet with, they can't get it. They can't afford it, right? So let's talk about the other way. And when I say the other way, this is a harder way. This is a more advanced, more technical strategy to do it. The harder, more advanced, more technical way is, ready for this? To gift it and wait 5 years. Now I know what you're thinking. Mitch, that was a pretty big drum roll for the word gift, wasn't it? Is it that difficult to take our stuff and give it away? You know, it's not that difficult, but it should be. If you take your stuff and you give it to your kids, who owns it? Who's in control of it? They are, right? So here's the issue. You don't want to blindly put assets directly into your kids' names, because you know what? I know that even though you trust your kids, let's talk about the problems. First, remember that farm? Take the property, give it to the kids, they're going to pay unnecessary capital gains tax. Again, like I said, I know you trust your kids, right? I know that if you thought if you put something in their names, they would give it back to you if they had it. And that's my point. What if they didn't have it? What if something happened to them? What if they got sued, filed bankruptcy, got divorced? I met with a family, right? I met with mom, dad, and their 3 daughters. Here's what they did. 8 years ago, they took a $400,000 piece of property. They gifted it to their 4 kids. Property's protected. But that's not why they came in. Here's what happened. The son wasn't with him at my meeting. You know why? Tragically, he died in a car accident. And at his death, by his will, 1/4 of that property passed to his wife, forever lost from the family. I know you got great kids, right? I don't know how to tell you this any better, but please watch out. Never blindly put things in your kids' names. You never know what's going to happen to your kids. The last thing you want to do is risk one of those problems. That poor son died in the hands of a drunk driver. Who could have predicted that? At his death, passes out of the family, gone forever. So here's what you should start looking at. Start looking at what I'll call an asset protection trust. All right, let's talk about how they work. First, put your real estate in. Properties, that means real estate again. Homes, farms, second homes, vacation properties, rental properties. Life insurance, how about this? Life insurance has 2 values. Death benefit, cash value. All right, here's the problem. They want you to cash it in if it has a cash value. Can you imagine? You've been holding your life insurance your whole life. All of a sudden you get sick, they make you cash it in. Get that protected. Money, I don't mean your checking account. I mean your rainy day fund. I mean that CD that's just sitting there, that brokerage account, the dividends just reinvest. I don't mean the money used day to day. I'm talking about that rainy day fund. That's what I would put into this trust. What are the benefits of using a trust? Think about those 3 problems. First, if it's real estate or stock, good news. They don't inherit it till death. What happens? Basis step up, right? Avoid any unnecessary taxes. You will retain control. It says up there technical control. Let me give you an example. You know, if you give it to your 3 kids and you get mad at one of them, you just give it to them outright and you get mad at one of them and you say, give it back to me. Good luck, right? But if you get mad at somebody here, just take them off as a beneficiary. That's technical control, right? And then the last one is safe from liabilities. If something's going on, your daughter's getting divorced, you don't have to do anything. She doesn't own it. She may never own it. I just showed you how you can take one of them off. In fact, if you're worried that prior to your death, the divorce is not going to be finalized, take her off. When the divorce is finalized, put her back on. Right? If you have not considered long-term care planning into your estate plan, please take out your sheet and write that down on one of those lines. All right, let me throw this together for you. Let me summarize some things for you real quick. All right, I met with this family here. These guys. The wife's parents were on the couch. They were around these 3 grandkids. They had 2 daughters. One was engaged. This one was married. Married couple had these grandkids. All right, here's the head. They had a bank account, brokerage account, IRAs, house 5 acres with a pond that these kids loved. All right, so here's the issue. They wanted to make sure that not only did they have a will to make sure things went the right way, but they wanted to make sure that things were easy for their family. They wanted to avoid probate. They wanted to make sure they had good, strong documents so they could sign for one another. And when they couldn't do it, their kids could do it as a backup. They wanted to make sure that the house with the 5 acres with that pond that those grandkids love was protected and would always stay in the family. They wanted some of that brokerage account to continue to pay the real estate taxes for that property even after they were gone. So we need to protect assets from a spend down and estate recovery. They may never go into a nursing home. They had those IRAs. We didn't want the kids to pay too much in taxes. So we did some tax planning. And you know what? They love that son-in-law, but they realized that if something happened to their daughter, somebody else might love him too. And they didn't want the assets that they left to their daughter to scoot out to him and off to some other family. So here's what we did. We created some extra trust to make sure that things stayed in the bloodline. And more importantly, if they got divorced in the future, that the spouse couldn't touch it. Inheritance planning, bloodline planning. All right, so here's my hunch. Your sheet looks a bit like this. You feel a little bit like this. All right, as I told you at the beginning, I want to offer my proven process to planning to you. Here we go. Here's what I'd like you to think about. Come see me. Come in for a consultation. There's no cost. Here's what I'm going to do. I'm going to ask you questions about you, your family, your assets, your income, your health. Bring in anything you think will be helpful. Bring in a list of what you got. Bring in statements, right? Anything you got. If you already have a trust, already have a power of attorney, bring it in so I can take a look at it. I'm going to review your situation. I'm going to tell you what I think you should do, tell you what it costs, and then I'm going to do something odd. I'm going to kick you out. I'm not going to let you do it that day. I think your head's going to be spinning just like it is today. It's like drinking water out of a fire hose. It's way too much information for you to comprehend. Not because I'm bad at explaining it, not because you're not smart enough to get it. It's too new. I want you to go home. I want you to come up with questions. I want you to talk to anybody you didn't bring to that meeting. Then come back. Come back in for a second meeting so we can help you understand all those, answer all those questions, make sure that you got it in more detail. If at the end of that second meeting you hate it, you leave. If you like it, you already know what it costs. I'm going to give you a list of things to bring back in so we can actually help you get gas in the car, so we can help you get the trust funded if we do that. And then eventually you'd come back and sign, right? Now, here's what I would almost say to you. Your first step is here, right? To me, truly, and I can't stress this to you enough, learning about these things that I'm not blaming anybody here for not knowing about. I'm blaming the advisors that you've talked to for not asking the right questions and going through some of these things, right? These are things that people should be talking to you about. Your advisors should be talking about. All right, do me a favor. I know people want to get out of here, and I know that some people might have some questions. So here's what I'm going to do. Real quick, I'm going to have you get out this yellow sheet, fill out your particulars at the top. You can, at the bottom, critique me if I did a good job, bad job. I look at these personally to make sure that this gets better for the future. But in the middle, there's 3 boxes. The very bottom one, if you're an existing client already, and I do see some familiar faces, I appreciate you coming back out and supporting us. And if anything has changed, as you know, check that box. We'll review your situation. In the middle, if you have an emergency, a bad diagnosis in the family, right? Somebody just went into a nursing home, check that second box. We'll get you in as soon as we can. And then the top one, it says contact me to schedule an appointment. If you check that box, and after you hand it in, I'm actually going to give you this book called 101 Questions About Estate Planning About Trust. But after you hand that in, what's going to happen is Maria is going to actually schedule an appointment to come into the office to sit down with me one-on-one. We can meet in Hilliard, which I think is tremendous, especially, based on the fact we've only been up in Centerburg for so long. But hopefully you take advantage of that opportunity. I think she has my schedule back there today, if anybody has that. But I appreciate that a lot of people might need to get out of here. So what I'm going to do is I'm going to sort of wrap up. But if anybody does have any questions, I'm happy to go through those with you now. But if you got to scoot, I won't feel bad about it. You're not hurting my feelings. Fill out the sheet, hand it in, get that book. Guys, I really thank you for coming out today. If you haven't realized this about me already, I really, truly hope you learned some things today. Please drive home safely. And again, hopefully I see you soon. Thanks, guys. Oh my God. Thank you so much. Thanks. Yes, go ahead. I'll do it. I can do it. Okay.
I'd just like to know where things are with the step up, because I have heard that they are doing away with the step up for inherited stock.
Yeah.
For your progeny.
So I don't know if everybody heard it back there. What she said was, in fact, last year about this time, they were really focusing on tax changes. And one of them was whether or not they were going to do away with the step up in basis. At this point, they have, it was brought up that one time. It was brought up about the estate tax thresholds going lower, faster. It hasn't been brought up again. So at this point, I haven't seen anything that's going into 2023. Right? No, her question, by the way, was, suppose somebody works with us and then the laws change. Here's what I would always tell you, right? I would always tell you this. About every 4 years, we elect somebody in office, right? It takes about a year to mess things up, right or wrong, right? I would say about every 5 years, come back in. But you know what? If you read something or you hear something, a rumor, call, right? Odds are we've heard it from somebody else, and we're happy to answer any of your phone calls. So please call. There's tons of ways to get in touch with us.
They have been talking about quite a lot of time. Keeping the money in IRAs and for 401k and putting it into the Social Security money.
I understand. So there's what she's asking about are all the rumors that are out there, what they may do in the future with 401ks and IRAs. And again, at this point, they're rumors. I haven't heard more about anything solid that would happen with that. Haven't heard that. Yes, sir.
When you say fund your trust, is that a monthly fee that you put in there, or you put it annually?
Okay, so the question is, when I say fund the trust, is it a monthly amount or an annual amount that you put in? No, what I'm really saying is, so you got this trust box, right? And you got this piece of real estate. You're going to fund it by transferring ownership of your asset from your name to the trust. That way the trust works, right? That way the rules as far as distribution of the trust, they distribute that asset at your debt. So you're funding it probably with your, what happens is people come in, we give them a list of things to bring in, okay? House, your deed, your car titles, your bank statements. What winds up happening is we prepare letters to get things in the name of the trust. And then what happens is once it's initially funded, usually things are okay, right? The only time you ever have to really do anything more is if you buy a new house, or you buy a new car, you open up a new bank account. It's very easy to put an asset into the trust. We'll give you all the information as to how to do it. And again, if you have a question about it, like I said to this woman, you would just call the office and we'll help you. Okay. If you want to sell it, like I said before, depending on the type of trust. So if you're looking at nursing unprotected, things are a little bit different. But if it's in that first trust designed to avoid probate, you want to sell it. Who's the trustee again? You, right? So you sell it pretty easy. Okay. Take it out of the trust. In that first trust at the very beginning about avoiding probate, not only you the trustee, but you're the beneficiary. So anything you take out, it goes to you. It's not until you pass away that the kids are involved. Did you have a question? Okay. Oh, all right. I know what you mean. So it's not, it could be the tax, but you're looking at the auditor's website, right? That shows that an asset, that a house is no longer in John Doe's name, it's now in John Doe as trustee of his trust, right? So that, I mean, I'm not sure what the question is, but yeah. So that house has been deeded to a trust. Okay. Yes. That's a great question. Here, I'm going to say that one. Let me say that one publicly. So her question was, how much does it cost? And here's going to be my bad answer for you. Okay. It depends. And I'm not trying to be difficult about it. I'll give you a range, right? So I've got a lot of families that, you know, they don't need a trust. They don't have a lot of assets to care about long-term care planning, or they already have long-term care insurance. You know, we do legal documents for families. We make sure things avoid probate. If it's just a house, we charge about $800 to do it. I've got some families that are worried about if they're driving down the road and they hit somebody that they can't sue them for everything they got, like attorneys or dentists or doctors who are worried, you know, if they go wrong with a medical procedure and their malpractice insurance doesn't cover them because they had a beer at lunch, that they want to make sure they're insulated from liability. We charge probably $10,000 to $15,000 for a trust. So to give you a better example, because it's difficult without knowing everything that you're interested in, to give you a better example, the example I had up there before, where here's what they did. They avoided probate. They wanted to protect certain assets from nursing homes. Then they wanted to protect each of their kids in the event something happened in the future. We charged a flat fee. What was it? It was $4,500. Okay. That's what we did. All the documents we did 4 trusts. Now that might differ a little bit for different reasons, right? They didn't have a lot of money in retirement accounts. In the future, if you had more retirement accounts, we'd have to do a different type of trust. So that's the best example I can give you. I mean, it's probably better than most people would give you. I don't know how to give you a better example than that, or better answer. Okay.
So the advantage of doing a trust is it doesn't go to probate and it's not public information.
Correct. The advantage of doing a trust is that it's avoids probate and it's not public. Now, again, to me, there's other ways to avoid probate that kind of do that too, right? So that's not, to me, an advantage in doing a trust. That's just avoiding probate. The advantage in doing the trust is, I don't know if you're married, but if you die and he remarries, that he can't give it to the new person, right? So there's different advantages. There's different ways to avoid probate, which give you avoiding probate and privacy, but there's other reasons to use a trust. But as that woman pointed out, you can find all day on the auditor's office who transferred things, but you can't see. Well, if you start an LLC with the Secretary of State, yes. But you can do but as far as public information, you can do a better job by truly making sure that things avoid probate, right? That way they don't have your kids' names, addresses, things like that, right? They might know that the house is in the trust, but they don't know where it's going to go. They got to wait around till you pass away to figure out where the beneficiaries are. I don't know who's first. I'm sorry, real quick. Let me go to her and then.
I set it up before the day. Like, you know,
Mhm. Yeah. So here's her question over there, especially, and here's what I don't know, right? I can't speak for every other type of attorney, right? Let me just tell you how it works at our office, right? So if you retained us today, we did this trust work. Here's what happens. We charge a flat fee. Phone calls in the future are covered. So if one of your kids gets married and you have some questions about it, call. You know why most people don't call attorneys? Because they bill every time you call. We don't do things that way. All right. Now, if the change winds up being somebody died, we do what we call compassion amendments at no cost. If you got mad at a daughter, we're going to charge you a little fee to change it, but it's usually about $100 to $200, right? But the reality is, what I want you to do is call. And the reason is because you may not need to change anything, right? We might already have it set up and you just don't realize that it's already set up to avoid that problem. So to answer, I forgot that gentleman's question. So once it's initially funded with the assets, if you buy something in the future, right, Now, if you say, you know what, I don't know how to get my car in the trust, I'll call Mitch, but it's Sunday, I'll wait till Monday. By all means do that, right? But if something happens to you Sunday night or you're worried about it, we're going to teach you how to get assets in the trust so you don't have to call every time you do something. Okay? Okay, I'm sorry, your question.
Got a question about, mortgage, like, if someone has, they have it in reverse mortgage, and they don't have anybody on it, they die, it goes back to.
The estate, if you have a reverse mortgage, go ahead. Well, if the spouse is on the deed, I didn't understand that. So if a husband and wife, right, is what you're saying. Okay. And she does a reverse mortgage against the house. Okay. Okay. Is it a reverse mortgage that did away with her payment, or did she get a lump sum of money out of it? Okay, so they got money. So what happens at death is the institution that did the reverse mortgage, they sell the house, they pay off that debt, and then the rest of it goes to the beneficiaries. Now, if she was in a facility on benefits, the state's going to lay claim to it too, right? Okay, good.
Now, when you say that the state claims for what, if you're on Medicare, Medicaid, or what?
Medicaid. All right. So what she said, I'm sorry, guys, I forget to keep doing this. What she said was, so the state comes back from Medicare or Medicaid. They come back from Medicaid for benefits they pay out. Now, one of the really new ones that they're doing is there's a lot of people. I'll give you an example. I had a family that they just retired. The only thing they had was their 401k. And when they retired, they didn't have any income. So they actually qualified for the state to pay their health insurance premium, which is subject to a state recovery, and the state can later put a lien against your house. So food for thought, right? Anytime they pay anything out of pocket, they can come back and get it after you're gone. I think her question was, have you made a book for dummies? This is a good book, really. It asks questions that, not a lot, you guys have asked some pretty good questions, but it answers a lot of questions that I think you would consider are those dummy questions. So I'm not so sure I'd say dummy, right? They're really good. You guys are asking great questions. I do. I think you'll find that to be a pretty good resource.
Oh, we had an online participant ask about how to get a copy of the book.
Oh, if they email, have them email.
I could put the email in the chat or
Get the
follow
email
up.
and we'll email it out to them.
Okay, sounds good.
And for everybody else, tell them that, obviously.
You said that
Good question.
cost, the funding is all your assets and any money in the bank account and everything. Now you want to write the check, what do you do?
Your question is, and you'll have to excuse me because today we talked about 7 different types of trusts. But if you have the technical trust from the beginning that's designed to avoid probate and you put your assets in, your question is, how do you write a check? You're the trustee. So when the bank account is funded to the trust, we send information. Now you could do this too, but it's time consuming. We send information out to the bank to tell them it's in the trust, and there's a document. They don't get to see your whole trust, so hopefully takes away some of that public record problem, but they get to see a document that talks about who the trustee is and what sort of responsibilities and rights and rules they have. So they get that document, so they know you as trustee have the right to conduct business that way. So when you write a check, you're doing it as trustee. When you die, they'll get a similar, I apologize, when they die, they get a similar one that has your death certificate and now who the acting trustee is and what rights and responsibilities they have. Okay.
Any tax benefit, tax income?
A trust like that one from the beginning, are there any tax advantages or tax benefits? It's invisible from a tax standpoint. So that trust uses your social security number. So you file your taxes just like you always have. Just like, did you have a question?
Your rental properties be in a trust or an LLC?
Should your rental properties be in a trust or an LLC? I would probably say they should be in an, ready for this crazy answer? They should be in an LLC and the LLC should be in the trust. Okay, here's why. First, the LLC gives you an extra layer of protection, right? The LLC, that if you don't know what that is, that's a limited liability company. So you take the rental property, you put it in an LLC, The rent goes into it. If it's a single member LLC, if it's just you, it uses your tax ID number. So accounting's the same. But what happens is if somebody sues you, they can only get what's in that LLC. That's why, this is obnoxious sometimes, but somebody who has 12 rental properties, sometimes they create 12 separate LLCs. Sometimes they put them all in one. If somebody sues, they can get everything. So that's one reason to do that, but that's an accounting nightmare, right? But the problem is that then your LLC is in your name, those shares are in your name, and at your death, they'd normally have to go through probate. So then you assign the shares in the LLC to the trust, and that's how it gets distributed. Good question. Yes. When a tax is formed, they have a tax ID number for that trust. So again, a trust that's solely designed to avoid probate, the tax ID number is usually your social security number. When you pass away, that's usually when your trustee then gets a federal tax ID number, because obviously it can't run under your social security number. So usually a trust designed again to avoid probate uses your social security number.